We have some very important news out of Illinois regarding one of the biggest Second Amendment battles happening right now. The Trump Department of Justice has officially stepped in on the side of gun owners, filing an amicus brief in a major case challenging the state's so-called assault weapons ban and its restrictions on standard capacity magazines. This is not just another routine filing. What makes it so significant is that the Trump DOJ is directly arguing that Illinois' rifle and magazine bans violate the Second Amendment and should be struck down. In their brief, they point out that Judge McGlin's earlier decision, which sided with gun owners, was correct and should stand. They argue that under Supreme Court precedent, cases like Heller and Bruen, the bans in Illinois cannot be justified. But it doesn't stop there. The Trump DOJ has also asked the Seventh Circuit for permission to participate in the oral argument scheduled for September. That means they don't just want to file paperwork, they want to stand up in court and argue against Illinois' bans directly. That is a major development, and it shows how serious this administration is about pushing back against laws that undermine the Second Amendment. To understand why this matters so much, let's rewind a bit. When Illinois passed its sweeping ban, known as the Protect Illinois Communities Act, it didn't just target so-called assault weapons like AR-15s and AK-style rifles. It also banned standard capacity magazines that millions of Americans legally own and rely on for self-defense, sport shooting, and hunting. Almost immediately, lawsuits were filed challenging this law. Several district courts granted preliminary injunctions, which temporarily blocked parts of the ban from being enforced. But Illinois appealed, and the Seventh Circuit stepped in, allowing the ban to stay in effect while the cases moved forward. This sparked emergency appeals to the Supreme Court, with gun owners and organizations asking the justices to step in and strike the ban down immediately. The Supreme Court, however, declined to intervene at that early stage. While that may have looked like a defeat at the time, it came with an important warning. Justice Clarence Thomas wrote that if the Seventh Circuit ultimately upheld Illinois' ban, the Supreme Court can and should review that decision once the case reaches a final judgment. He reminded the courts that the Second Amendment cannot be treated as a second-class right. So now, with the Trump DOJ stepping in, filing an amicus brief, and even requesting to argue in front of the Seventh Circuit, the stage is set for a major battle. This is not just about Illinois. The outcome here could shape the future of rifle and magazine bans nationwide. While all of that was unfolding, the lower court judge overseeing this case, Judge Stephen McGlin, decided it was time to move forward and issue a decision on the full merits of the case. After reviewing the evidence and applying the Supreme Court's Bruen standard, Judge McGlin once again ruled that the Protect Illinois Communities Act is unconstitutional. In his ruling, he struck the law down, reaffirming that Illinois' sweeping ban on commonly owned firearms and magazines cannot survive constitutional scrutiny. Of course, Illinois was not willing to accept that outcome. State officials immediately appealed to the Seventh Circuit, arguing that Judge McGlin's legal analysis was flawed. They claimed he misapplied the Bruen test and should have followed the reasoning that the Seventh Circuit used in earlier cases, such as Beavis v. City of Naperville. But now things have taken a dramatic turn. The Trump administration has stepped in to support the challenge against Illinois. In its recent brief, the Department of Justice made it clear that Illinois' law directly violates the Second Amendment. The DOJ pointed out that just 3 years ago, the Supreme Court issued a landmark ruling in New York State Rifle and Amp. Pistol Association v. Bruen, specifically warning states not to treat the Second Amendment as a second-class right, governed by a separate set of rules. Yet only months after that decision, Illinois went ahead and passed one of the broadest so-called assault weapons bans in the nation, outlawing some of the most commonly used rifles and magazines in America. According to the DOJ, this action by Illinois defies the Supreme Court's clear directive. States cannot prohibit arms that are in common use by law-abiding citizens for lawful purposes, whether that be self-defense, sports hooting, or hunting. The DOJ then laid out 3 compelling reasons why the Seventh Circuit should reverse its course and side with Judge McGlin's ruling. First, they argued that key parts of the Bevis decision were simply wrong, even when judged against earlier Supreme Court case law on the Second Amendment. Second, they noted that multiple Supreme Court justices, including Justice Clarence Thomas, who authored Bruen, have since made it clear that they disagree with Bevis and similar lower court rulings. These justices have openly signaled that the Supreme Court is likely to grant review soon to correct those errors. Third, after Bevis was decided, Judge McGlin conducted a thorough, multi-day bench trial. He heard detailed evidence and made factual findings, all of which showed that Illinois' law directly violates the Second Amendment. Specifically, he found that the semi-automatic firearms and standard-capacity magazines targeted by the law are clearly in common use by law-abiding citizens for lawful purposes and therefore cannot be banned under the Constitution. To strengthen its case, the DOJ also pointed to the Supreme Court's recent decision involving Smith & Wesson and the Protection of Lawful Commerce in Arms Act. In that ruling, even justices like Elena Kagan, along with Clarence Thomas, acknowledged that the AR-15 is not only widely owned, but is in common use for lawful civilian purposes. In fact, it is one of the most popular rifles in America today. All of this underscores just how strongly the Trump DOJ is backing this challenge. And they didn't stop at filing a brief. The administration has now taken an even bigger step by formally asking the Seventh Circuit for permission to participate directly in oral arguments. In their motion, the DOJ requested 5 minutes of speaking time during the arguments, which are currently scheduled to last 45 minutes for each side. The request explained that Assistant Attorney General Harmeet Dillon from the DOJ's Civil Rights Division would personally present the oral arguments on behalf of the United States. Importantly, the plaintiffs in the case have already agreed to give up 5 minutes of their own time so that the DOJ can speak. That means the government's participation won't change the overall time allotted for arguments. The defendants, Illinois officials, also confirmed that they do not oppose the DOJ's request. If this motion is granted, it will mean that when oral arguments begin, the Trump administration will be standing side by side with the plaintiffs, making the case that Illinois' ban is unconstitutional. That is a huge development, and it shows just how much momentum this challenge is gaining. This development is very significant. All parties involved in the case, including the state of Illinois, have agreed to allow the Trump Department of Justice to participate in the oral arguments. With that level of agreement, it is very likely that the Seventh Circuit will approve the DOJ's request to argue in the upcoming hearings. Even if the Seventh Circuit ultimately rules against the plaintiffs, the fact that the Trump DOJ is now actively participating in the case is a major shift. Having the federal government step in and argue directly in favor of the Second Amendment during oral arguments strengthens the foundation of this challenge as it makes its way through the courts. It also increases the likelihood that this case could eventually be elevated to the Supreme Court. Oral arguments are officially set for Monday, September 22nd, and that will be the key moment to watch. It will be very interesting to see how the state of Illinois and the Seventh Circuit judges handle not only the Trump administration's amicus brief, but also their direct participation during those arguments. The DOJ will now have an opportunity to lay out, in clear terms, why Illinois' law violates the Second Amendment, and that carries a lot of weight going forward. That being said, it's important to remember that the Seventh Circuit has not historically been favorable toward Second Amendment challenges. Their track record has often leaned toward upholding restrictions rather than protecting gun rights. However, this time they are facing mounting pressure. The Supreme Court has already issued multiple warnings to lower courts, reminding them not to treat the Second Amendment as a second-class right. If the Seventh Circuit once again chooses to disregard that clear guidance, this case is exactly the kind that could be taken up by the Supreme Court. In fact, Justice Brett Kavanaugh has already made statements signaling that the Supreme Court will need to address these rifle and magazine bans very soon, likely within the next term or two. This Illinois case is one of the very challenges the justices have identified as being worth watching closely. And if the Seventh Circuit ignores Bruen and rules against the plaintiffs, The involvement of the Trump DOJ will only strengthen the argument for the Supreme Court to step in and take the case. The federal government's support makes it far more likely that the justices will see this as a case worth granting review. So, that's where things currently stand with the Illinois PICA case. The Trump DOJ is poised to play an active role in oral arguments, directly supporting the plaintiffs and pushing back against Illinois' sweeping ban. This adds a powerful voice to the pro-Second Amendment side and could be a turning point in the fight against these types of restrictions. We'll see how the Seventh Circuit responds in September, but either way, this case now carries national implications. As always, I'll continue to keep you updated as new developments unfold. If you found this update helpful and want to support the channel, one of the best ways is to subscribe. I truly appreciate all of your support, and I'll keep bringing you the latest as this critical case moves forward.